Yes.
But you didn't pay for the work.
I did pay for it.
Defendant says she never received any payment from you.
Okay. Well, I have evidence on my phone. I have evidence on my bank statements.
How did you pay her?
I paid her with cash, and then I did pay her...
No, just a second. For the extensions. I'm not talking about for the mascara that you bought.
Okay.
I'm talking about for the extensions themselves, because she says that you're a scam artist because you paid her through some vehicle. What kind of vehicle was that?
It's like a Groupon is how you're supposed to buy the voucher.
I don't know how that works.
I asked her, do you want me to pay on the deal or do you want me to pay you in cash? And she said it either way, so...
I just want to see that you paid her.
Okay.
Okay.
I can show you here because it didn't show up on the email.
Listen to me, Ms. Cook. That's very easy to ascertain. Do you have a bank statement? Is that what you want?
I have a bank statement that I took out $32 for the mascara.
The $32 for the mascara, she says that you paid her $32 for the mascara. You actually paid her the $100 for the lashes.
Well, it says an agreement that I paid her and then I went back to her. She's compliant with everything on my text messages that I have paid her the money. So I approve on here.
Find me the place where she says, not that you paid it, that she got the money. Did you ever get the money?
I have a receipt. I got the money for the mascara.
No.
I do have that receipt, but no, ma'am. I never received any money for the eyelash extensions.
How is she supposed to pay you for it? With a Groupon?
Yes, it's KSL, so it's just like Groupon. You go online and you purchase a voucher, and then you bring the voucher at the time of service.
And she never did that?
No, she had asked me if she could pay in cash. So to my understanding, she was buying the voucher off of KSL.
And that you would be reimbursed by KSL?
Yes, ma'am. A couple weeks after the service.
So that what I need for you to show me is proof that you bought it via KSL for the lashes. Bird, do you know what they're talking about? You buy a voucher?
I can't understand it, but I don't use it.
But if you bought a voucher for which you're paying the service,
right,
and it's all done over the internet,
right,
I assume. I assume you get some sort of a receipt that you have purchased a particular voucher for a particular service, or...
Right, they either send you the voucher via online, and then you take it in, you show her the voucher, and I guess there's numbers
they credit her
account, and she signed up with them, so she, so she would know
whether or not the money.
The blue text message right there, she can read that. We were going to do a deal. When I first texted her, I asked her, I've never gotten these lashes before.
I don't want your whole story. I just want to see proof of payment, because she's got a counterclaim. She said you never paid her.
Okay. She didn't give me a receipt, so.
Would you please show me here? I'm not reading this whole conversation. I just want you to show me that she acknowledges she got money from you for doing it, or show me via your credit card, via some mechanism on your internet that you paid for the lashes.
I didn't get a receipt, but I did go back to her and she was perfectly fine with me going back with her without, I don't see why she would be so happy and inclined for me to go back to get them fixed. If, do you want me to do the Groupon or cash? And she said, and I said, I'd taken out cash. Can I just pay you cash?
You didn't pay her cash.
I did pay her cash.
No, you didn't. That I don't believe. That story is different than the one you suggested to me 5 minutes ago.
But what was the story I suggested?
That it was paid for in a Groupon.
No, I had looked and found her on a Groupon. I didn't buy the Groupon. I asked her, do you
Listen, you have proof of the $32 for the mascara, right? The same way you have proof of the $32 for the mascara, I want to see the proof that you paid her.
Okay, I don't have proof of that I paid
Because
her.
you didn't pay her. And I'm telling you that you didn't pay her because even your complaint doesn't say I paid her.
I had texted her and said, can you please, the first thing I texted her was, will you please just pay for them to get removed? I don't even want my money back. Just pay for them to get removed. And nothing back.
And that was on what date?
I'd need my phone to look at it. I'm sorry, what was the date that you wanted for?
When you said to her, will you just pay to have them removed?
Okay. Do you want me to read it to you?
I want the date.
Oh, it's the 14th.
So, you went to her on the 8th. You went back to her on the 12th.
13th.
Well, you told me 2 minutes ago it was the 12th, that you went back to her on the 12th.
Oh, sorry.
Because you said to me, why would she see me again if I hadn't paid her?
It was on the paper, the 13th. It was the 12th. Sorry.
That's what you told me a moment ago.
Okay,
So you went back to her on the 12th, and then you left. And then on the 14th.
Okay. I said, I am really unhappy with the work you did. I went and showed somebody that has been doing it in the business for over 10 years, and she has told me that it is completely wrong and that with a mascara, you're only supposed to put it on the base and not all over the lashes and hardly ever use it at all. And there are several lashes that are twisted and there was gaps in between. I would like either a refund or I'm going to have to report you to Double. I'm really sorry, you're really nice.
You report you to who?
Double, the Department of Public Licensing.
Go ahead. So?
I'm really sorry, you're really nice, and I don't usually do stuff like this, but I really don't have a lot of money, and to spend that money on this, it was like a treat for me because I don't get to get this kind of stuff done a lot. I'm just really unhappy, so it's up to you, and you can tell me what you would like to do to proceed. She never responded to me. And then I said, if you just want to refund me $100 or even $75, I will not contact anyone. It's up to you. She didn't respond to me.
Why didn't she respond to her?
They were in, and then you come and get a service and you don't even pay me. So, I mean, honestly, I figured, okay, that's the good thing about going through KSL because I'm protected. So therefore, she can handle it with KSL. I called my KSL lady that I did the ad with, let her know of the problem as well, and I let it go as far as until I was informed with the other stuff that we'll address in a moment.
Your Honor.
What?
May I speak on behalf of this case?
Who are you?
My name is Tammy McNeil. I'm a master licensed esthetician.
You want to talk about the subpar work that the defendant did? Is that what you want to talk about, or any?
I want to talk about the fact that I brought my license here for you to. The subpar work is perfectly fine within my realm of expertise.
Well,
to discuss. And you're laughing?
At the time that you performed this service.
Yes, ma'am.
This is a service that requires a license.
Yes, ma'am.
Show me the license.
I do not have the license. I was certified to be an eyelash extension specialist in 2012. In 2013, they had changed the law, and you had to have a separate license. I am an insurance agent.
Just a second.
Yes.
So the answer is, the long and short of it is you did not have a license when you performed this work.
Yes, ma'am.
Okay.
Judge Judy continues in a moment.
You had...
Says, esthetician Felicia Gallegos owes for damages resulting from bad eyelash extensions. Felicia is countersuing for non-payment of services rendered and harassment.
Okay. And how much did it cost?
$230 complete with her taking them off and putting them back on.
$230?
Yes.
Is what you paid to this lady?
Yes.
And that's what you're entitled to, because she doesn't have a license. You had no license.
Initially,
you had no license.
No, that's understandable. And if I was aware of that, I got fined.
Just a second. You had no license.
No,
you
that's fine.
performed a function that requires a license without a license, and the plaintiff was dissatisfied with the service. If she was satisfied, we wouldn't be here.
If she was satisfied, dissatisfied, she went up, came and saw me 2 times, and I have a screenshot of her saying she loves my work. So,
$230. Is that what she paid you?
Yes, Your Honor.
Judgment for the plaintiff. That's all. Thank you.
What about my
2-year-old Stephanie McGuigan for their share of damages to their apartment?
What is your last name?
McGuigan.
And you're Mr. Toll. Are you a couple?
Yes.
The 3 of you rented an apartment together, and all 3 of you were on the lease, correct?
Yes.
When did you rent the apartment, Mr. Craig?
June 20th of last year.
And when you rented the apartment, the rent was to be divided 3 ways.
Correct.
Things didn't work out. I actually don't care why they didn't work out. It's not relevant.
Yes.
Yes.
And he told you he was moving out.
No, he did not.
He did not tell you he was moving out. He just left.
We asked him.
His third of the rent. We all agree on that.
Correct.
Despite the fact that he wasn't living there in October, November, December, January, February, March, April, and May. 8 months. Are we all clear?
Yes.
He moved out. You said you asked him to leave, which would make it even more ludicrous for him to continue to pay the rent after he left, but there doesn't matter to this case. And the landlord charged all of you $1,800 and some change for damages to the apartment.
Yes, ma'am.
You 2 didn't pay those damages. Do you, maybe that's easy, do you deny that he paid the whole amount of the damages?
I do not deny that, no.
Great. Okay. Thank you. So first, Miss McGuigan, you and your boyfriend should turn around and say a big, hearty thank you to Mr. Craig for paying the rent on the apartment so that you 2 lovebirds could live there by yourself at a substantial discount. He left. He could have said to you, I'll pay you for this month's rent, but I'm not paying for anything else. You told me to leave. So thank you goes in his direction. A big thank you. Now, you lived there for 8 months. Why didn't you fix it? You lived there for 8 months.
I'm not going to pay for the damages that he did.
Hey, tell me what he did. You, tell me what he did.
He broke a toilet.
Okay, just a minute. He broke a toilet. Are you telling me you lived there for 8 months with a broken toilet?
It was functionable.
So you didn't live there with a broken toilet. Tell me what part of the toilet was broken.
The toilet seat and the cover cap.
The toilet seat and the cover to the toilet seat.
The back lid.
Tell me how he did that.
Services she promised for a spa party.
Ms. Chiappetta, you're asking this court to award you the money that you paid to the defendant who runs a hair salon / spa. You paid her for a spa day that you were arranging for a relative of yours?
For my future mother-in-law, my mother who's here, and my 2 sisters, and myself.
And how did you find
Several spas in the Shady Side, Pittsburgh area.
Is that where you live?
I live 30 miles north.
So that you weren't familiar with things in the area?
I'm very familiar with Shady Side.
Okay, so you are familiar with the area?
I am, yes.
Great. So you called spas, several of them?
Yes.
And?
I booked specifically, called several spas, and Sherry's Spa was one of them.
Okay. And you worked out an arrangement with her?
Yes.
Did you have a written contract with her?
No.
And did she send you a spa menu?
She did not.
Did you ask for one?
Over the phone, I did.
And did you get one?
I did not.
So why did you go?
Well, I called and I specifically asked her if she could have there. What do they specialize in?
Just a second. So she said she could.
Yes.
5 body massages, and you asked her specifically how many masseuses she had there.
Yes.
And what did she say?
She said, I have a fully staffed salon and a fully staffed spa, and every single person in your party will be taken care of at the same time, because that was one of the questions that I asked her.
Of course, you don't want to spend 6 hours there. Everybody has an hour.
Exactly.
Okay. And did she quote you a price?
She did not. I asked
You
her.
didn't ask her what it was for a massage?
I did. I asked her over the phone if she could business consult, and I sell insurances and...
Insurances? What kind of insurances?
For businesses. Business insurance.
You sell insurance for business?
Yes.
Insurance singular for business?
Yes.
So that you're a businesswoman?
Yes.
Well, you don't sound very much like a businesswoman to me.
Your Honor,
I've created many spa days in my life for my daughters, for my friends. I get a menu.
Your Honor, I go to spas a lot.
Correct?
Absolutely.
Right. That's what you do when you want to have things written out and know exactly what it is. Are you playing with me? You have a very peculiar look on your face. Really, I'm serious with you. And there's only one part of your whole story that I would have any sympathy for, because what you do is you want all your money back, because you say that the only person who was doing massages was her.
Yes.
How many people did you have giving massages that day? Look at me.
Myself.
How many people?
Just one.
Well, that's an unsatisfactory way to run a business. And what did they tell me? They were getting a.
There were 2 in getting manicures and pedicures.
Okay,
and
so
then 2 in a room for facials.
They weren't
because we
Just a
double
second.
up our rooms.
Hold on. Don't speak.
Okay.
2 of the women were getting manis and pedis by separate people.
No, that.
Who was?
And
how many people of all the estheticians that were employed at your salon?
The girls that were there was 3 of us total there. 2 of them, myself and my staff.
No, that means yourself and 2 others were there.
That's right. Myself and 2 others were there.
Jump up. Names. Sarah what? Okay, and you have her phone number.
Yes.
And is she licensed to do what?
No, she is not licensed.
Then she can't do anything.
She's a support person.
She can clean out the pans.
Clean, support.
If she's not licensed, she can't do anything in any state except clean up your place.
Correct.
And who is the other person?
The nail tech.
Nail techs have to be licensed.
She's licensed.
Really?
Yes.
I don't believe you. Okay. I actually don't believe you. You know, I was unsympathetic with her situation, except I think you're a hustler. Except I think you're a hustler.
Well,
anybody else licensed but you as an esthetician, so that everybody was sitting around doing nothing. How much did you pay her?
$700 deposit.
the Wednesday before the services. And at the end of the day, I said, Sherry, we have to come to a different agreement.
You're going to come to a different agreement. How much was the remainder of what you paid her?
$480, but for a total of $1,180.
How many people got massages that day?
0. Nobody got a massage.
Why?
We don't know, because we asked her several times, Sherry, when are we going to get massages? What's happening?
What were you doing for the day?
We were waiting. We were sipping on some tea. Her nail tech started with manicures, which we did not call for.
Okay, but she did manicures.
No, she actually did polish changes because they did not cut cuticles. They did not do manicures.
That's not true. That's simply not true.
I have a witness.
Just a second.
Pedicure. I have a witness.
This is all lies. You're lying about everything.
What happened to the massages?
No, you are lying.
Hey.
No.
Sorry.
No.
What happened to the massages? I need some basic information. You and Mr. Dorsey were married.
Yes.
For how many years?
For 19 years.
And you have 3 children?
Yes.
Your children are, according to your complaint, 21. That would be you? What's your name?
Tyler.
And you are 17?
Yes.
Name?
Trenton.
And then there is a young teenager.
8-year-old.
An 8-year-old?
8-year-old.
And what's his name?
Tegan.
In what year were you and Mr. Dorsey divorced?
June 2011.
And in 2011, where were the children living after the divorce?
Tyler remained at home with his father, and Trenton and Tegan moved with me to my mother's house.
You were living with your mother?
Yes.
Until what year?
Say February 2012.
Why did you leave your mother's house? Look at me. You hear I'm talking? And I have a cold. So I want to hear from you. Why did you leave your mother's house?
I was starting to think that she didn't really care that much. And she was starting to get too bossy and pushy.
So you didn't like the rules?
Yes.
Did your mother permit you to go to your father's house?
Yes.
Now, when you went to your father's house, what did you take with you?
All of my clothing.
Continually?
Yes.
So far, is all of that correct?
Yes, ma'am.
Great. Now, the first part of your lawsuit, Miss Dorsey, is that the current Mrs. Dorsey, your first name is?
Terry.
Terry, opened up a joint bank account with Trenton, and she overdrew that bank account. And since it was a joint account, his credit is now impaired.
Yes.
So you want her to reimburse the bank so that that clears his credit. Yes. That's the first part of your lawsuit. Yeah. Why did you overdraw the account?
First of all, I didn't realize I had overdrawn. Second of all, the only time I went and withdrew money from the account is when Trenton asked me to, because he didn't know how to withdraw money from the bank. He had called me from the bank and asked one of the tellers to talk to me and teach him how to write a check to get it. The next time to the bank per my husband and Trenton to get the money to pay for the Jeep.
Who put the money into this account?
Trenton did.
From working?
Yes.
Also, Your Honor, it was also, money was withdrawn from the account to cover Trenton's cheer charges. Mrs. Martin agreed to pay half of them, and then when it came down to it, she told him she would not pay half of it. He was living with us, so it was up to us. So at that time, Trenton asked me to go withdraw part of the money to do that.
That's your problem, Mrs. Dorsey. You have to replenish and make the bank whole so that his credit is whole, because you're the grown-up.
Yes, ma'am.
And the bank is overdrawn in the amount of $500 and some odd dollars. What is the total amount that the bank is overdrawn?
$558.19.
And I was not aware of any of this.
You have proof of that?
Yes.
I'd like to take a look at it. Where can I see that, please? Thank you. Trenton, was this the only bank account that you had? This joint account with your stepmother?
At the time, yes.
Okay, $558. You're supposed to keep tabs on that, and if you're having a fight with his mother because she didn't pay for half of a bill, that doesn't mean that you allow his name to be attached to something that's not his fault. Okay, let's get to the next part of your lawsuit. There came a time, Trenton, when you made a decision to go back to live with your mother. What year? Do you remember?
Yes, ma'am, 2013, October.
And do you remember why you went back to live with your mother?
Because Dana had been pushing me away from my dad.
He didn't like the rules, Your Honor.
So, in any event, you decided to go back to your mother. Your mother is complaining, next part of her lawsuit is, that both Mr. and Mrs. Dorsey filed a restraining order against you that was based upon nothing. The only thing that I want to know is, did you or anyone on your behalf go to
son's behalf? Did I go to?
No.
Okay, sorry.
Let's not play word games.
I'm not trying to.
He's a minor.
Yes.
He moved home.
Yes.
When he was at his father and stepmother's house, he had a room of furniture.
Yes.
Is that right?
Yes.
You didn't move in with that furniture because I asked you early on in the game what you moved in with.
All of the furniture.
Yep. And you told me my clothes, my shoes, and my Xbox. So my question to you is, did you or your minor child or anyone on your minor child's behalf go into their house when they were not home and remove the furniture that had been in his bedroom? Let me put it to you this way. Did there come a time after your son came back to you, because now he didn't like their rules.
Right.
First he didn't like your rules, then he didn't like their rules.
And I understood that, yes.
Did there come a time when you found his furniture in your house?
Yes.
Did they give it to you?
No, they did not. The mother already had furniture. That the boys, since they were visiting off and on so much, that we would leave the stuff in the house until he got the house sold.
Your Honor, she came back. Okay. Sorry.
You went there without permission of the owners. When they weren't home, you or somebody on your behalf took property out of their home. That's what courts are for. That's
not on my behalf, Your Honor. It was not my idea. I had nothing to do with it.
Well, then you have stolen property in your house.
Your Honor, went and got his stuff.
No.
He was living there in the house, and he took his stuff with him.
Listen to me. They had a right to file a protective order against you, because that wasn't the only time Trenton went back to the house. Right, Trenton? If that's what your mother is saying, you went back to the house again. And when you went back to the house again, this was over some other property, not your bed and dresser. This was... I'm asking you a question. I mean, I'm writing this scenario. I haven't been in this business 2 seconds, you know. So the door was locked.
Yes.
Whether they had the locks changed after the first instance, I don't know. Probably if they were smart. So did you cut through the screen?
Yes.
That's burglary. That's why we have courts. We have courts because if there is an issue with regard to property, you come to a court and the court makes a decision as to whose property it is.
But his father gave him permission
to cut through the screen and go into the house?
To have his property
back.
back.
Just a second. To cut through the screen and go into the house?
To have
of course
his property
not.
back.
And he lives there.
Dana was the one that denied him of the property, not Jeff.
He cut through the screen and went into the house.
I understand.
That's burglary.
Judge Judy continues in a moment. Martin and her sons, Tyler and Trenton, claim the boy's father, Jeff Dorsey, and his wife, Dana, overdrew a bank account and filed a false restraining order. The defendants are countersuing for stolen items and school fees.
Now, if she, and I'm not putting any medals on her chest, filed a protective order against her stepson for
her son's restitution and the return of child support he overpaid.
Mr. Lipscomb, there are 2 parts to your lawsuit. You and the defendant have a child together. I assume that that's you?
Yes, ma'am.
And the child's primary custodian is his mother.
Correct.
And has been with his mother for how many years?
All of his life.
And how old is he?
19.
But you are an involved dad. According to what I've read, there was a time when your son was in some difficulty with the law, and as part of the resolution of that case, he was ordered to make restitution.
Yes.
That's the first part of your lawsuit. And he had a period of time to make that restitution in another jurisdiction, another state. And in order for the probation department in the state where you live, which is which state?
Illinois.
To let him move out of state, you were advised that he would have to completely pay off his restitution.
Yes.
And that's the first part of your lawsuit. And how many years did he have to pay the restitution?
Over 4 years since the beginning.
And when was the order made?
I guess it was made in the beginning of the case back when he was 14 years old. I'm not sure the accurate date.
When he was 14?
Yes.
And he had 4 years to pay off the restitution. Is that correct?
Yes.
So that would have been the responsibility of both of you to pay that off anyway, because he's a minor.
Correct.
Who was the restitution to be paid to?
The county of DuPage.
Well, but ultimately it was to go to towards the victims.
Correct.
Okay. So you understand, Ms. Johnson, that you were legally required, and I assume from the time he was 14 up until the time when he was 17 or so, Had you been paying this piece of the restitution?
No, ma'am.
Well, who had been?
It hadn't been paid at all.
But it had to be paid.
Correct.
Well, how did you intend to an agreement? Mr. Lipscomb says you had an agreement. You said you would pay for half, but you had a legal obligation to pay.
I never told him that I would not pay him. I was not financially able to pay him at the time.
Oh, well, that's a different story. Then we have a different set of circumstances. So you acknowledge you owe minimally for half
of Kendall's restitution.
Of his restitution.
Correct.
See how easy that was?
Yes.
Right? Now let's get to the second part of your lawsuit, which is slightly more contentious, and that is that you overpaid child support.
Yes.
How that happened is overpaid in your child support obligation. Would that be correct, Ms. Johnson?
Yes.
In what amount, sir?
$834.73.
So he overpaid child support over the course of his obligation to pay child support. You found out about it. The ball's in your court. Let me hear.
When we found out about the overpayment in child support back in 2013, when all of this came to light about Kendall and the restitution and everything, and well, when Kendall and Urban and his father had a falling out. I'm sorry.
I don't care about their falling out. I'm talking about the money that was an overpayment, $834.
Yes.
So you tell me why you don't owe him that money. It would be like a stranger sending money, it lands in your account, and you spend it. You have to explain to me why you're not responsible to return this money to him.
Because Mr. Lipscomb stated to me in order to mend the bridge at the courthouse.
At the courthouse?
After I decided to terminate, just lost my train of thought, child support, because we went to court to terminate the child support.
To terminate it.
At 18, when he graduated?
You didn't decide to terminate it.
Well, yes.
From high school. So you went to extend the child support beyond his 18th birthday. You did, in fact, extend the child support to his graduation. So you didn't elect to terminate the child support. It terminated by operation of law. Now, did you have that conversation with her in the courthouse?
No, ma'am.
Yeah, I don't think you did either. You have any communication with Miss Johnson with regard to this $834?
Just verbally talk to her about the child support payment. As far as what she's saying about his graduation fee.
Okay. What's your first name?
Kendall.
You'll only have one mother and one father. And it sounds to me as if for at least a period of time, a good period of time, your father was involved in your life, right?
Yes, ma'am.
It would be stupid for you to cut him out now. Really stupid. Make peace. It's easier. Do you understand? Judgment.
Cleefers McCowan Jr. for personal property and filing a false police report.
Court come to order. All rise.
Have a seat, please.
Case 2143, Simpsons versus McCowan Jr.
Thank you.
You're welcome.
Miss Simpson, you lived with Mr. McGowan for, looks like 7 years is what you said.
Yeah, yes, ma'am. It was off and on.
What do you mean off and on?
Well, I had another residence as well.
Okay.
And
it's going to get more complicated, I see, than less complicated. You lived off and on, according to you, with the defendant's brother, who is now deceased. Yeah. It is your claim at one point in your papers that you and the defendant's brother were married.
Yes, ma'am.
He passed away.
Yes, ma'am.
And it is your claim that the defendant owes you money. He was the executor of the estate, and he owes you money for property that he took from the house and for filing a false police report against you, I assume indicating that you took things from the house.
Yes, ma'am.
Okay. Mr. McGowan says that you and his brother were never married, while he indicates in his papers there might have been some sort of ceremony of marriage.
Yes.
That his brother somehow must have told him that he never filed the marriage license, so the marriage was never valid.
That's correct.
Is that correct?
That's correct.
Okay. Well, let's go to that for a moment.
Yeah.
Yes, it's sort of curious and takes me back to law school days. And believe me, that really tests my memory. Were you at the ceremony where your brother married the plaintiff?
No, ma'am, I was not.
When did your brother tell you that there was a marriage ceremony?
I probably heard it just throughout life.
You mean throughout life for how long?
From the time that he had any dealings with her.
So about 7 years ago?
Yes, ma'am.
So you asked your brother whether he was married?
Yes.
How long ago was this?
I would say 4 years ago.
Okay, so 4 years ago, you say to your brother, I understand that you, what's your first name?
Mona.
Mona got married.
Well, so he gave me an insurance document, and I was like, "Wow, what's going on? What the person that gets the money upon if he demise?
If he died,
right? And
you had a VA insurance policy.
Yes, ma'am.
With you as the beneficiary.
Yes, ma'am.
Okay, and so he showed you the insurance policy.
Well, he sent it to me in the mail.
Okay,
or email or electronic, and so I said, "Wow, what's going on?" So then I started to ask different questions, and he said, "Well, don't worry about that. We're not legally married."
No, you have to tell me. I said to him.
I said to him, "So doesn't your wife
Isn't she the beneficiary?
I don't want to be involved in all this."
Right.
And he said, "I am not married. We went through a ceremony, and you have 10 days to file the
marriage license.
The marriage license in Las Vegas.
Okay.
To solidify the marriage." And then he said, "I never filed it. We are not married."
May I?
Just a second. Did your brother tell you that he had ever told Ms. Simpson that he never filed the marriage license?
No, we never had that conversation.
Okay. Well, because you say in your answer, sir, that my brother was too smart for that, he never mailed in the license.
Well, he told me because there was a problem between these two. And so we talked about that, and he said, "No, I'm not married to her." And he said, "You have to file the document," and I never filed the document. And I have a copy of that right here.
Miss Simpson,
yes, ma'am.
Tell me when this ceremony took place in Las Vegas.
April 2013.
Did you travel there with Mr. McGowan?
Yes, ma'am. We moved to Vegas together.
Who was at the ceremony?
It was no ceremony. What happened was I don't know what this is. What happened was we went to the Justice of the Peace, and the 10 days is not acronym.
No, don't.
I apologize.
Don't tell me.
We had 1 year to go to like a pastor or minister or something like that because we just went to the Justice of the Peace. And there's officiant or something. Officiant has to do it so you can become married permanently.
So you knew that you were not legally married?
Well, it was legal, but it would be official if you don't do another step within a year. And
I understand that, but you never did the other step.
We didn't, only because he was sick, ma'am.
I don't care what the reason was. I don't care if he was watching Yellowstone or because it doesn't matter why.
I respect that.
What? You can get hooked on that.
No, yeah.
I understand.
So I don't care what the reason is. You knew that your marriage, because it wasn't confirmed, according to you, within a year that you weren't legally married.
Yes, ma'am. And
okay, just a second. That's all I want to know. That makes my life much easier. Because, Mr. McGowan, I want you to listen to me very carefully. Under what you told me, under the events that you told me, so you should have kept your mouth shut.
No, it's okay.
No.
It's going to be okay in the end. It's going to make a lot of sense in the end.
No, I understand that it's going to make a lot of sense to me. We're going to follow the money. But I just want to tell you and the people who are watching this that when I thought about your answer, that you said your brother was too smart and didn't file the necessary document within 10 days, my view of that scenario was that she could still consider herself his wife. Because if he fraudulently, in an attempt to deceive her, didn't mail the marriage license in, she would be the beneficiary. I'm just letting you know that. You understand what I just said?
Yes, ma'am.
Because he committed a fraud on her. He would have committed a fraud, your brother, on her into leading her to believe that they were a married couple and they had the responsibilities and the benefits of a married couple. But she says she volunteered that she knew they weren't married.
Yeah.
So I don't even have to address that.
And it's okay.
Just a second. I know where I'm coming from.
Okay.
So Mr. McGowan, the person that you were involved in for a period of years, on and off, you had your own place, but he was ill for a certain period of time. Was your brother ill?
No, ma'am.
No. Just a second. Key says no. You say he was ill for a great portion of that time. Shh. Just a second. For a great portion, as his caregiver by the government.
The VA, yes, ma'am.
By the VA, to be his caregiver.
Yes, ma'am.
Well, that would be inconsistent with being his wife, to be his caregiver. Because if you're a wife, you don't get benefits from the VA. If you are a non-relative and caring for somebody who requires assistance, you may get assistance. And how much was the VA Just answer my question.
Yes,
this is not my first rodeo.
Okay, I understand.
How much was the VA paying you a month to take care of, what was your brother's first name?
Marcus.
How much were you being paid to take care of Marcus? Because you say that one check you didn't get because of him. It's part of your lawsuit, so you know exactly how much you were paid. How much?
$2,057.55.
A month?
Yes,
and when
ma'am.
did you start collecting that?
2014.
Woo! You are a legal stranger, so you must have filled out forms to say that you were married.
No, I was considered a family member. I was no longer considered the wife, but I was considered...
Well, you're not no longer. You were never his wife.
Ramona Simpson claims her ex-boyfriend's brother, Cleefers McCowan Jr., threw out her personal belongings. Cleefers is countersuing for damage and stolen property.
Okay, so there was a reason why you didn't continue to solemnize the marriage ceremony that you went through in 2013, because you started to collect $2,000 a month from the VA in 2014 that you couldn't have collected were you his wife. That's a yes.
No, it isn't, ma'am.
Oh.
Receiving the benefits from the VA, you have to be a family member. You have to be related to that person in order to get this stipend pay. It wasn't a regular VA payment, and it's for relatives. You have to be a relative for that veteran.
What are you getting? Oh,
yes, it's true. I loved him, and I cared for him, and he was sick the day I met him.
Just a minute, you both disabled veterans?
Well, my disability was not as crucial as his was.
How much do you collect?
I very minimum, because
I asked you a question. That's a very minimum.
Yes.
It's not a number.
Yes, it's $300 and some change. But the thing is, Your Honor, may I speak, please? He was sick from the day that I met him, and I was taking care of him prior for that. This was his idea, because he was familiar with the veterans and the system. This was his idea that we can receive funds, and it stayed right in the household. We were living together. It was stayed in the household, and that's okay with them.
I thought you told me a moment ago that you had your own place.
No, not then, ma'am. Not then, when we moved back from Vegas, because we stayed in Vegas for approximately 3 years. When we moved back from Vegas, he had purchased a home and everything, and it was supposed to be okay. We were going to be together. But he started living another alternate life, which he was very familiar with, because he's introduced him to so many people. I don't even care about that. I still continue to take care of Marcus. It was no longer a romantic situation.
Now you still continue. You had your own place.
I lived both places, because he needed me more there than he did when we was living together.
What kind of alternative lifestyle was he doing that he needed you there part-time?
He was seeing other people and stuff like that.
He was seeing women.
Pardon me?
He was seeing other women.
He was seeing other people, yes, ma'am.
Okay, so he was seeing other people. But you, let me finish.
Yes, ma'am.
But you continued to receive the $2,057. You knew you weren't married. That money was coming directly to you. It wasn't coming to him.
Well,
it was coming to you. At what address?
He was giving me a portion from his bank account, and then when we discontinued everything, there was nothing physical. Then I was receiving my full allotment at that point, but I was still taking care of him, taking him to the VA, taking him to the hospital.
Wait just a second. I don't care. Don't go like this and like this. He's a legal stranger to you, and you're getting $2,000 a month to take him to the VA.
Ma'am, he was not a legal stranger.
He was a legal stranger to you. Legal. He was not your mother, father, brother, sister, or husband.
Ma'am, he was a dear friend of me. He continued to be a friend, honestly.
Well,
and he knows that. We went to several places together.
I'm setting up for myself scenario. I was prepared for somebody, quite frankly, Miss Simpson, who had been defrauded by his deceased brother into believing they were married. She took care of him when he was sick. And all of a sudden, now that he's deceased, his brother comes in, kicks her out of the house, and takes all of his property. That's the scenario. But now I understand that that is not the case, that you knew you weren't married, that for 8 years you collected $2,000 a month for taking him to the doctor's offices, to the vet, to taking care of him in the house. But you understood that he was seeing other people, that you didn't have an exclusive relationship. Now I understand it. And you did receive a certain benefit from that, because when you moved back from Vegas, you went to your own place because he was having an alternative life that had nothing to do with you. At that point, Was the money going to his bank account or yours?
It was going to his bank account, ma'am.
Okay. Well, you say that he notified the government. Part of your lawsuit is for 1 month's check that you say, or 2 months that you didn't get. And you say you didn't get it because he notified the VA or somebody notified the VA. I don't care who notified the VA. What I want to know is, were those checks immediately preceding Mr. McGowan's death going into his bank account or yours that he had?
His. It was going into Marcus's bank account.
Okay, and he was giving you money from that bank account?
Prior to his death, yes, ma'am.
Right up to the time he got sick and died?
Yeah.
Okay,
yes,
and how much would he give you?
He would have given me $2,057. $2,000.
All right.
No,
okay,
you mean total?
No,
I'm sorry.
No. I get it. It was not what I thought, but I get it.
Ma'am, may I
okay,
please
money owed
something?
for the return of property. What property?
The property, which is my funds. I have jewelry that was missing and clothing that I never received because he kicked out his niece and boarded up the house.
Just a second. Was your brother taken to the hospital?
Yes, ma'am.
On what date?
28th of August.
Just a second. Did you take him to the hospital?
I had his daughter to call an ambulance. I got to Marcus's house and I followed him to the hospital. Yes, ma'am.
Hey, well, you want to just answer my question? I actually understand the whole scenario. You understand that I do understand the money part. I get it. So when you say his daughter called the ambulance and you got over there from your house?
Yes, ma'am.
Okay, and who do you live with there?
My daughter and my son.
And in whose name is the lease?
My daughters, my son, and myself.
So all three are on the lease?
Yes, ma'am.
And how long have you had a lease at that address?
2017.
Okay, so we're talking about 5 years that you've had an alternative address. You have an answer for me?
There is a Veterans Affairs program of comprehensive assistance for family caregivers. It says $2,800 a month, but based on a fee schedule that can change. So the 2057 fits within the range.
And does it define family members?
It doesn't define the family caregiver, only that the VA may appoint someone who's part of the primary family caregivers to the veteran, but it doesn't identify who qualifies as a family caregiver.
As a family caregiver. And that's the act that you were under. But you were not a member of his family.
Yes, ma'am.
You were not a member of his family.
Well,
not a well.
Than that.
Not a well. This is not a well. You're living with your daughter, your son, on a lease since 2017. You know he's got an alternative lifestyle that has absolutely nothing to do with you. He was giving you the $2,000 a month. I don't know why. I don't even have to get into that.
But you were not that individual.
But you were not a family member. If this is for family,
it does go to the veteran to then give the family caregiver, though.
Okay, but you are a legal stranger to him. So you must have filled out forms to say that you were married.
No, it's up to that. It's up to that individual, the veteran, and I know how the procedure goes. It's up to that individual. I was considered a family member. I was no longer considered the wife, but I was considered.
Well, you're not no longer. You were never his wife. So if he filled out a form and
I'm okay with that, ma'am, because I could have.
Okay, so he had the right. You were never his wife. He had the right to board up the house, whichever it is, and you weren't living there for 5 years. You had a place. So if you had clothes there and your jewelry, what were your clothes and your jewelry there?
No one has came to the home as another woman in that home. I was always there. He has no proof of evidence that I was not there. So basically, I had their clothes there because I stayed there. I lived there.
Forget it. You were more than compensated with $2,000 a month. What's next? I don't believe that you leave any valuable jewelry at his house.
I was there most of the time, honestly.
You don't need valuable jewelry if you're taking care of a sick person.
Ramona Simpson is accusing defendant Cleefers McCowan Jr. of throwing out her personal belongings.
Okay. Do you have any of her property?
No, ma'am.
Did you dispose of any of her property?
I didn't. She had no property
Just
there.
a second. I don't believe she had any property there either. Anything of value.
And I did.
Okay.
Can I?
Excuse me.
I did find what the VA considers a caregiver. So if you're a spouse, son, daughter, parent, step-family member, or extended family member of a veteran, or if you live full-time with them, or if you're willing to live full-time with them if they designate you as the family caregiver.
So technically,
if you're willing to live with the veteran full-time, you could be qualified as a family caregiver, but it's up to the veteran to declare their own family
caregiver if you live there full time.
Yeah.
Yeah. But she stated if you were willing to, and I was always willing to.
Okay,
And because
good. I don't feel as if you were shortchanged, madam, at all. And I don't believe that you had anything of value in the house. So your case is dismissed. Now we're going to get to the second part of your claim. You say she took property from the house?
Yes, ma'am.
What property?
She took jewelry, guns.
What jewelry?
Chains, rings, cufflinks.
Show me.
Entire.
Show me. How am I going to figure that out? You have photographs of things?
Yes, I have some photographs here.
Was paid in the arrears, first of all. So me not getting paid for, and this is really not a big issue to me, what he's saying, because they're all lies, and I'll tell you the truth.
Just say, I'm not saying anything, madam. All I'm saying is you have no case, because I don't believe that somebody who lived in a lifestyle, as you've described, as you've described to me, which is you have your own home, where you're on a lease since 2017, where you said to me he had an alternative lifestyle, but I still took him to his VA appointments. I took him, and I was his caregiver, but I lived with my daughter and my son. I don't believe that you leave any valuable jewelry at his house.
I was there most of the time, honestly.
You don't need valuable jewelry if you're taking care of a sick person.
But
Can I see?
I was taking was also friends, ma'am.
I've decided your case.
I respect that.
This is just what had happened to looking for everything that was taken in there.
I don't care. Who cares? What are you showing me? You showing me that the place is a mess, that somebody went through it?
I'm showing you what...
I don't care.
Okay.
I don't care. Prior to his death, when had you seen your brother last?
I had seen him about 5 days prior to that.
You live close by?
I was living in San Diego at the time, and he lived in Highland, which is 79 miles up the 15 freeway.
Okay, so 5 days prior to the 5 days prior that you saw your brother, when had you seen him before?
We see each other quite frequently. We have family barbecues, this, that, and the other. I'm retired. I go.
Okay, would you return these to him? These don't show me any jewelry.
Okay.
It shows me that the house looked like it was picked through.
Okay. Thank you.
What else?
So quite frequently.
That's it. Did you get a VA benefit from your brother for his insurance?
From the life insurance
policy? Yeah, that's from the VA.
Yes, ma'am.
And how much did you receive?
$2,600.
Who paid for his funeral?
I did.
How much was that?
$1,100 or $1,200.
So you took some of the insurance money and paid for it?
Yes.
Did he have any other valuable asset?
He had quite a bit of stuff. We're in...
Great, so I don't have to deal with it. Your case is dismissed. We're done. Thank you.
This court is adjourned.
You know what? I have a lot of respect for the judge, but she didn't listen to me.
Well, I'm happy that the judge made the decision that she made.
He's a habitual liar.
Thief. My brother died, and within a half a day went over and burglarized the house.
This is something that he can laugh about, and he's going to go and tell the whole world that I'm still a liar. I'm still a this, that, and the other.
There is quite a bit of items that belong to me that this person stole.
That you can love someone and not be married to them. You can help someone and not be married to them and making love to them. I was genuinely there to help Marcus because I love Marcus.
The devil. I don't want the devil, you know, the devil.
He barred me from the funeral. I didn't fight it because the respect I have for his family and for Marcus. I could have went there. No. I said, you know what? I won't be there.
I hope that she crawls back in the rat hole she came out of and does whatever she does.
You know what was interesting in that case, Sarah? When I read the complaint and the answer, I had a whole different vision.
Me too.
Of what the arrangement was. And based upon what the defendant wrote in his answer, that his brother, with regard to the marriage, to his brother telling him, I'm too smart, I didn't mail in the papers.
Read like fraud a little bit.
Right.
But she was in on it. She knew. She didn't complete the steps.
She didn't complete the step for a different reason, but she knew
that they weren't legally married.
That they weren't legally
married.
Which
changes the whole game from a legal perspective.
Right. Certainly the fact that the case is currently in probate made my life a lot easier. Anyway, it should be a warning signal when you get married out there, folks, and you have a marriage license, because I performed enough weddings to know you have to seal it, sign it, put a stamp on it, and usually put it in the mail within 3 days of the ceremony. So,
Court come to order. All rise.
have a seat, please.
Hello, Judge. Hi. Case 2081, Kemper versus Fortenberry.
Thank you.
You're welcome.
Mr. Kerper, it is your claim that the defendant breached a contract with you. The contract was a verbal contract. And the nature of that breach was the defendant envisioned in his mind the lyrics to a song. That was his business. And he asked, according to you, he asked you to put music to the lyrics. Am I understanding that correctly?
The latter part is true. However, it was more than just a verbal contract. It's also in writing.
Okay, I'm going to take a look at it.
Okay.
That's important. And according to your complaint, you did in fact write the music.
Correct.
To his lyrics.
That is correct.
And you had an agreement in writing that you would share the profits of any exploitation of that song.
That is correct.
With him.
Yes.
And that he breached that agreement.
Yes, there's also an agreement that he would give me proper credit whenever he was using that.
So now I would like to see, if you say there was a written contract that's signed by both parties. That's what I want to see.
Okay. So this was the original version, which he offered me 25%.
Just a second.
Okay.
Just a second.
Sorry.
Okay. This contract is pretty straightforward, and it's signed by both parties, and it says Luther Winston Fortenberry created a song, Baby I Got a Gun, and Charles Kerper, that's you, transcribed it to guitar.
Correct.
So what this contract says, I just want you to understand, Mr. Kerper, is that the defendant created the song, and you transcribed it to guitar. That's what it says. And that was written in January of 2016.
Correct.
It's signed by both people.
That is correct.
Okay.
Yeah.
Now, what you're showing me is something else.
How it started to change over time.
Listen to me. This was your written contract.
Right.
Any change in that contract, unless I could really find that there was a meeting of the minds with regard to it, has to be in the same formality of this contract. It says, by the way, Mr. Fortenberry, this contract was written January 30th, 2016.
Yes, I'm looking at it.
Yes. When did you create this song? In what month and year?
About a year. I don't know exactly, but I was at a popular comedy store, and the manager of our show.
What show?
The Ding Dong Show.
What's the Ding Dong Show? When you said our show, was he involved in that?
Just with this transcription.
I was involved with other elements of the music as well, with Mr. Fortenberry.
Well, right now this says transcribe. But I asked you a simple question. When did you write this song?
At least a year before this contract.
At least a year before January 30th, 2016.
Yes. And I was singing it regularly a cappella at the club.
Okay. But you asked to transcribe it. That's what it says. Now, this was done at the time that you transcribed it to guitar.
I would argue I'd never transcribed it because...
That's just a second. That's what this says. It doesn't say will transcribe it. It said transcribed it.
Correct.
To a guitar that they both agreed to submit for sale.
Correct.
Asking price will be $10,000 to rent and $10 million to sell it outright, and you will split it 75-25. That's what this says.
That is correct.
Now, did you ever rent it?
I never rented it or sold it.
Just a sec. Well, I'm asking you these questions. You never rented it?
No.
And $10 million to sell it outright, and you never sold it?
No, ma'am.
Okay. So it was neither rented nor sold, which was your original contract. And you have no proof to the contrary, that he neither rented it nor sold it.
I have evidence that he did use it in other
productions. It doesn't say that you can't use it.
Right, that is correct.
Okay, now you want to show me, sir, because this is what your action is. You want to show me that this original agreement was somehow modified.
Correct. That was signed about 4 or 5 days later. You have the papers that's stapled behind. I confronted Mr. Fortenberry and I said, this is not a transcribing project. This is a rewriting project. What he provided to me was not usable for transcription. And on the next page, we have a text message exchange that I highlighted where he
just a second.
Shh. Sorry.
Well, this is a text message from him to you.
Correct. And he
right?
acknowledged.
And just a second, that's not acknowledging. That's a text message from him to you. Do you have your response to this? You can't unilaterally change a contract that's in writing. I mean, if you have an offer and an acceptance.
Right.
So where is your response to this?
I don't believe I had a response in the history of messages I was able to retrieve, so.
Then this is irrelevant.
Okay.
So far, we have this. We have a writing signed by both parties, which is complete. It says what you did, what you will be paid in the event of a rental or a sale. Now, you want to show me something else?
So going forward, what he did was he registered the song with a registration company in San Diego. He did that without my knowledge.
Just a second, that's irrelevant. This is your contract. Show me where it's a violation of this contract. This contract says you transcribed it to guitar. If the version that you transcribed with a guitar is either rented or sold, you will get 25% of the revenue.
Right.
So we already went through that. You do not have any proof that he either rented it or sold it. It doesn't say that you will be given credit. It doesn't say what your credit will be. If you have a modification where he agreed that you will get certain credit and you accepted that, I will see that. Okay.
This is the most recent agreement signed in August 21st, 2018. It's dated August 8th.
I don't know what this means. Mr. Kerper agrees to release Mr. Fortenberry from any financial liability for work performed prior to the date of this document, that is prior to 2018.
Correct.
Payment for Mr. Kerper has invested in this ongoing project to date. What did he pay you? Because it doesn't say here.
He didn't pay me anything. What he did was he gave me some camera equipment, which he'd promised me, which was outside of this project. And he gave me $300 as what was deemed a celebratory gift because we were wrapping this up.
No, that's not what this says, Mr. Kerper. Mr. Kerper, we read a contract literally.
Right.
This is a poorly crafted document, but it's clear in regards to Baby I Got Gun.
Right.
Mr. Kerper, that's you, agrees to release Mr. Fortenberry of any financial liability for work performed prior to the date of this document.
Correct.
Payment by Mr. Fortenberry to Mr. Kerper will be considered compensation for time, costs Mr. Kerper has invested in this ongoing project. And what you're telling me is the payment was some camera equipment and $300.
I would say it was not the camera equipment, it was the $300.
What the camera equipment?
This is some camera equipment I had. I had sold him some of it prior, and he had offered it back to me as a gift because I had invested so much work into this project.
You got 5 more minutes of my time.
Okay.
You have no case.
I believe I do, ma'am.
No.
I'm sorry, Your Honor.
Sorry, you don't.
Charles Kerper claims musician Luther Fortenberry owes for breach of contract and copyright infringement.
Now, those are the 2 written contracts. You have any further modification of those contracts in writing?
Yes,
Just a second. I'll see them.
Okay.
This is a contract in writing, 2018. This is 2016. And this was agreed by both parties. So the last agreement was you got $300. Did you pay him $300?
$300 in camera equipment, about $1,500 worth.
Okay. He started to mention that, and then he backtracked. Okay. Next written contract after 2018.
Yes, was not a transcription.
Mr. Kerper is to be understood as the music man behind the music and not a transcriptionist. Well, who do you want that to be noted by? Mr. Kerper is to be understood as the music man with capital letters.
Right.
And I don't know what that means.
This was his wording.
Well, then you should have fixed the wording.
I should have, you're correct.
I don't know what a music man is. It's not a trademark, it's not a copyright, it's a nothing. I don't know what it means.
So I wrote the music, which is in the version which he's using currently. I wrote that from scratch. There was no transcribing.
That doesn't say that. Nothing here says that. The only thing this says is Luther Winston created this song, Baby I Got Gun. That says he created it, you signed it. You wanted to clarify it. You wanted to be known as the music man, not just the transcriber. I don't know what music man means. And you got paid pursuant to this, although it doesn't say this, but you acknowledge it. You got paid $300.
Okay. Also in that agreement, it also says that I'll be given credit in future uses. It says that.
As the music man. You want him to say you're the music man?
Credit, which he did not give me
Just
credit.
a second. You want him to say, whenever he performs the song, Baby You Got Gun, if he gets up to perform that, I wrote this song together with Mr. Carper, and I want you to understand that he's the music man. It's interesting when people sign contracts and they have no idea what they're doing. Okay, let me see the next contract that you have.
So this is an agreement which is supposed to be a performance agreement with his producer from the comedy club.
Well, just a second, let me take a look at it.
He's...
Shh. Well, this is exactly what this says. This says this agreement, and this is August of 2018. And who sent this, by the way?
Mr. Fortenberry sent that to me.
Okay, it said this agreement gives Luther the right to perform music as the opportunity arises. Luther is further released of any further financial responsibility or debt owed making music. Charlie Kerper will be referred to in the future as the music man. This payment will be for goods and costs making music for $300 and camera equipment. If any referral is made in the future as to who wrote and...
Correct.
Okay? He sent that to you. Where is your response?
So he sent that back to me on August 8th.
Just a second.
Okay.
He sent this to you. So I would like to see your response to this. I agree to your terms. I disagree with your terms. If you agree with the terms, then I might accept that as a modification of a contract. If you say I disagree with the terms, then there is no modification. We go back to these two signed agreements.
Correct.
Where is your response to that?
Can I explain what happened after that? He's emailed that to me. I was here in LA, and I didn't have an opportunity to entirely go over it, but we were trying to meet with him at a restaurant and also at the museum to have this resolved. So I had my phone only to look at it, and he was playing hardball with me that day. So he sent me these emails saying he had signed these agreements which included making referral to me and clarifying that I did in fact write the music, which he claims I transcribed.
I need your response to him.
Okay.
If there is no response, we have these two agreements.
So the response was this. That night, he finally agreed to meet with us.
In writing.
Yes.
I want what you sent to him in response to this email.
Well, I called him on the phone and I said, can we meet so we can sign this and put this fast so the music video could be moved forward? And he wanted a performance agreement so there wasn't any questions whether or not they could use the music in the video. So I arrived at his apartment. He made us wait outside for half an hour.
Okay, Mr. Kerper, I really don't care.
Okay, I'm sorry.
It's not relevant.
Yeah.
What's relevant is if you had a subsequent offer and acceptance to a new contract, a modified contract that he made via email, and you responded to him via email that I accept those terms, or if you sent it to him and said, these are the terms I want, and he wrote back and I accept your terms, unless you have that, you are bound by. Right. And according to this contract, when referring to this music and referring to you, he has to refer to you as in capital letters, the music man.
Correct. Giving me credit. Correct.
No, he has to refer to you as the music man.
It says here in this contract, I'm sorry, if any referrals made in the future as to who wrote and performed parts of said music above, Charlie Kerper will be given those credits.
Yeah, as a music man.
No, it does not say music man here.
Where?
It should say it in the, not that one. Not that one either, the other one.
There's no other, I only have two written contracts.
This is his original email to me that he sent me before the contract we're discussing, and it has my response. I have my response attached to it here. I'm sorry, Your Honor.
Okay. Who wrote, your offer is hostile and very lowball for what you're asking?
I wrote that.
I reject it.
Absolutely.
I'm not interested in selling.
That is correct.
Well, that doesn't modify. That means he made you a subsequent offer after these two agreements. You said, I don't like that offer. So there was no change in these two written contracts, one of which called for payment, which you acknowledge you received in the form of $300 and camera equipment.
Charles Kerper is accusing musician Luther Fortenberry of breaking their contract. Luther claims he already paid Charles for his services.
Mr. Kerper, I want you to understand, you're looking at papers. What you're not understanding is, if you are going to modify a written contract, you have to do it with another contract in which there is an offer and an acceptance. He made an offer to you in this. You rejected the offer in your response.
Actually, that email he sent first, he worded it differently, and that's
the point. It doesn't matter. You rejected it.
I rejected the part that included the sale.
Just a second. You can't take pieces of what he says. If you're going to modify a contract which is clear, or as clear as it can be if two lay people write it, and which has been executed and fulfilled by terms of payment, because there was an exchange of cash and goods, which is indicated, this is what I'm going to do, and you said to him, I reject it. It's a low ball offer. So we're going to get back to, is there a subsequent modification that says, in addition to the $300 and the camera equipment and the fact that I will refer to you if I refer to anyone when he's singing the song, which I've never heard. I've heard of patter, where somebody talks about patter, and so-and-so wrote the song, and he wrote it when he was mourning the death of his dog, and then sings the song. That's patter. That's what I understand patter is, the chatter before. So if he was going to chatter about who wrote the song, he'd have to say, and the man behind the music is Mr. Music Man. That's all this says. And he's never sold it, and he's never rented it that you can establish.
He has used it in film productions?
He can use it. Your contract doesn't prevent him from using it, sir.
The final, I'm sorry, but the first one I gave you is the final. That was what led up to the...
No, this is a clarification, because you asked, right? And this is your final payment, $300 and camera equipment, because that's what you both agree that you got. There is no modification.
There is, though.
Well, then show me.
On the top line of the final, it says it'll be used exclusively in the Ding Dong Show and nowhere else without permission. And that is what is...
Just a second. It says this agreement gives Luther Bambury the right to perform name music in the Ding Dong Show and the promotional video.
Correct.
And?
That's it.
So?
So that is what he's limited to as far as performance.
Okay. And?
And he went and used my music in other productions with...
Well, show me.
Okay. I also have lyric sheets showing that...
Listen to me, sir.
Yes.
I've already explained to you what this case is about. It's a contract case.
Okay.
I'm not going to go through contracts. You have no modification of a contract unless there's an offer and acceptance. The only two contracts you have are here. I absolutely read this, and it says this agreement gives Luther Fortenberry the right to perform music named in the Ding Dong Show and promotional video.
Correct.
That's what it says. You say he used it in other places.
That is correct.
There's no remedy if he uses it in other places. You only have a remedy, sir, if he sells it or rents it. And you're not asking for injunctive relief. There's no action.
What he did with it, to be honest.
What?
I don't know what he's done. I've asked him for a complete statement of where he's used this and what payment.
Mr. Carper.
Yes.
You're the plaintiff.
Yes.
It's not his burden. It's your burden. What you're saying is he was limited to using it on one particular program, according to this, and promotional. And he's used it in other places. And I said, put your hand down. When it doesn't appear that you're losing, you're supposed to keep your mouth closed. It's your burden to show me that he used it in other places. That's first.
Okay.
Show me.
I can do that. I have the papers. I had it quite orderly before I came into court, and as nerves happen.
You can look for it, sir. I'm just advising you that your action is for breach of contract. That's what you filed. Right now, I have two contracts. One contract was fulfilled with the payment of $300 and camera equipment. There is an agreement here, however, that says he can use that music on certain things. It doesn't say exclusively on certain things. He says he can use it on the Ding Dong Show and promotional video. I assume promotional video, if you're inferring what that means, is for the Ding Dong Show. Now, it doesn't say it. If he uses the music someplace other than the Ding Dong Show and promotional video and he gets paid for it, I get a certain amount of money. Your original contract provides for a 75-25 split if the music is rented or sold.
Right.
That's what it provides for.
So when I accepted the payment on the contract, that was with the notion that he was going to give me credit in the future, which he has not done.
Okay. We're done here, Mr. Kerper. It's unfortunate, but you are bound by the terms of this. The one in 2016 is crystal clear. You're a transcriber, And as a transcriber, you will get 25% if the music is either rented or sold. Subsequently, there was a writing that says you don't want to be known as the transcriber, you want to be known as the music man.
Your Honor,
So
I did not transcribe anything. I wrote the music,
okay.
and that's why
Mr.
the
Carper, we're
subsequent
done. You got paid
paper-
$300 for writing the music and camera equipment. We're done. Your case is dismissed.
This court is adjourned.
Mr. Fortenberry approached me to transcribe a piece of music he
Well, I'm sorry she had to listen to so many lies.
presented me as completed, which it was not.
And I'm glad she had something in print, like contracts.
I helped develop the lyrics further and also write the music.
I hoped that he would see the truth
Well, there's always more songs, isn't there?
and correct his lies.
While I really appreciate that these two plaintiff and defendants had a written contract, it's always a risk as a layperson to write a contract yourself. It has to be fully integrated, all the points have to be hit, and one major part that was lacking here was a remedy section. So if the plaintiff is claiming that he deserves some sort of credit or some sort of payment for a show or an exploitation of the song going forward, there needs to be a sentence, at least, that's a meeting of the minds as to what's going to happen if that condition is not met. In the future.
In the future, because the contract, the second contract in 2018, clearly said he was paid. And he was
And
paid.
he signed it.
And he signed it. He was paid $300 and some camera equipment. The defendant said it was worth $1,500. I don't know whether it was or it wasn't. Anyway, it was inartfully done. You have to give them credit for trying.
Yes.
For trying. You know, they're music people. They're artists.
Yeah. Language and specifics and details is more our forte as lawyers.
More important, it's so frightening that I think I have a memory somewhere back here of the Ding Dong Show. So I'm going in the back now and look up the...
For car damage.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case number 2084, Popyachev versus Gilbert.
Thank you.
You're welcome.
Mr. Popyachev, you were driving in your car, 2008 BMW.
That's correct.
And that was on the 14th of November of
That is correct.
last year. Tell me what time of the day this accident happened.
It was approximately 3:15 p.m.
So daylight hours.
Yes.
And tell me where you were going.
I was going eastbound on Sunset Boulevard in Beverly Hills. I was driving
Eastbound on
Sunset Boulevard in Beverly Hills. I was driving in the right, so-called slow lane when I tried to make a right turn.
Where?
It's a intersection. The name of the street is Palm Drive.
Is that intersection controlled by a light or stop sign?
No, there is no stop sign or a light.
At that intersection?
That is correct.
I assume somebody has a video or a photograph of that section that would demonstrate that there is no light. You do. Is there a light or a stop sign at that intersection?
No, Your Honor, there's not.
Did you put on your signal indicator?
Before I reached the intersection.
Was there traffic that day?
Yes.
A lot?
Very light. It was Sunday.
So far, Mr. Gilbert, is that correct, that there was light traffic on that day?
Yes, Your Honor.
And you were traveling on a motor something called a Vespa, which is a small
scooter, yes, Your Honor.
but motorized.
Yes, ma'am.
And I don't know about these things, does a Vespa have to be registered and have a license plate on it?
I do have
It's
a
yours.
license plate on the Reddit.
Okay, so your Vespa is registered as a motor vehicle, and you have a license plate.
Yes, Your Honor.
Now tell me what happened, sir.
As I proceeded to make a right turn onto Palm Drive, I just heard an airflow. It was a big bang. It was an impact.
On your passenger side?
Yes, on my right passenger side. And I realized that there was a small motorcycle.
Okay. May I see the damage to your car?
Yes.
Sarah Rose, get me the price of the 2008 BMW 7 Series.
Will do.
Thanks. What you're talking about is this damage, sir. Is that correct?
Yes, front passenger.
I see.
Yeah.
I've just made a circle. Can you see the circle that I've made?
Yes, that is correct.
Okay. And that is, Mr. Gilbert, where you hit him with your Vespa.
It's where he hit me with his car.
No, he can't hit you sideways, sir.
He sideswiped me.
He can't hit you sideways, sir. He can't slide into you. Now, whose ever fault this was, I'll try to figure it out. But you hit him because this is the area of impact. Cars don't go sideways, they go front. You have pictures of your Vespa?
Yes.
I'd like to take a look at them.
Your Honor, based on a 100,000-mile BMW 7 Series, between $4,700 and $7,800 is about the range.
I just want to know, because that doesn't show me much, actually. Okay, so I can't see the front of your Vespa, sir. I assume that the front is the end that's damaged because I see the back.
Yeah, the front end was completely collapsed.
So the front of your Vespa was damaged because that's where you hit him with your Vespa.
No, you're
The
not.
back
That's
end
incorrect.
was not damaged, nor does it look like the sides are damaged. These are the pictures you gave me. The only thing I can't see is the front crushed end. Am I correct that I can't see the front crushed end? Okay.
Yes.
So now I'm telling you that based upon these photographs, yours and his, you hit his car. Okay, now that's the chart. Whose chart is that?
It's from the police report.
Great. Now, the police report doesn't show a bike lane there or any other lane. It shows that there's a car traveling in a car lane. And why is it that you were driving where you were? You were behind him initially.
No, Your Honor. I was traveling eastbound down Sunset, heading to work. He was right next to me. When we got to Palm, he turned into me, pushed me. I barely was able to keep control of my vehicle.
Is what you're telling me that your Vespa was never behind his? This you're not getting. I want you to get this right out of your mind. Your whole car isn't worth $10,000. Let's be serious. I don't have all day. Do you have a bill?
And later today.
And I know you're dying to tell me that there was noise there, that you couldn't live there, that it was terrible. Well, that's what happens when you live in a place with a whole bunch of other people.
Kaloyan Papyanshev claims fellow motorist Spencer Gilbert owes for car damage after hitting him with his Vespa.
Is what you're telling me that your Vespa was never behind his?
No, I was never behind his vehicle.
Do we have any other video?
I do have a dash camera.
Play it again, please. Start from the beginning. So let's go slowly. Okay. Well, it's clear to me, Mr. Gilbert, that you came up behind him. Just go back a little bit. You weren't right next to him because...
I was next to him because as he slows down to make his turn, that's when he makes contact with me. I was right next to him the entire time.
Impossible. May I see the police report, please?
Yes. There's actually 2 police reports.
May I see them? Was anybody given a summons on that day? Nobody. Neither party was given a summons, is that correct?
No.
Were questioned, and the opinion based upon the witness's testimony and yours, and the fact that the police officer actually heard in the video the clicking of the turn signal indicating a right turn approximately 5 seconds before the right turn was executed according to the police officer as a result of viewing the cam that he had, the video, that he was making a slow right turn. He had turned on his signal approximately 5 seconds before, and you were coming up on him on your right. And it says, based upon the video footage, I determined that the first car, and that would be his, should not have been placed at fault for this collision because he activated his turn signal and made a safe turn to go southbound on Park Drive. The fault of the collision is on the part of Mr. Gilbert for violating 21-755 CVC, which states in part that the driver of a vehicle may overtake and pass another vehicle on the right only under conditions permitting that movement safely. I'm reading you the police report. Do you have another police report?
Yes, I do, Your Honor.
Prior to this or after this one?
This is the only police report that I know of.
Oh.
I know this is what my lawyers gave me.
Oh, well, I'm going to show you this one, sir.
Yes, ma'am.
And this one was after viewing the cam.
Yes, Your Honor. My police report predates his.
Predates it. Well, that's after the officers looked at the dash cam, heard the signal, and saw you coming up from behind. I'll take it back now. I've seen the damage on your car, sir.
Yes.
Which, well, I wouldn't like to have it on my car that's 14 years old. It is on your car. It's not worth $10,000. Your whole car isn't worth $10,000, sir. So if you want to show me a reasonable estimate for fixing that, I'll be more than happy to look at it.
Yes, I do. And this estimate was given to me by the only body shop that is authorized by BMW.
I'll find another body shop for a 14-year-old car. I'm certainly not going to consider giving you anything near the value of your total car.
I had the entire door replaced, but it's still...
Replaced by whom?
By a body shop.
Good.
Yeah.
And if you had the whole door replaced, you must have a bill. This you're not getting. I want you to get this right out of your mind. Your whole car isn't worth $10,000. Let's be serious. I don't have all day. Do you have a bill for the door that you replaced from a body shop, which is what I said a moment ago?
No, I do not have it with me. The vehicle is still due paint and dents and scratches repair.
Well, they're going to fix the car, and if they can fix the car for $2,000, have it fixed. That's my judgment. Judgment for the plaintiff. We're finished.
This court is adjourned.
Certainly not happy about it.
I am happy. It is something.
The problems that this gentleman's caused my life.
It happened in about 2 seconds.
I was like riding right next to the dude and he just turned into me and I went into the wall and that was pretty much it.
I had to call 911 immediately because I wasn't sure if he's dead.
Because of what he did, I wasn't able to go to work for 2 weeks. I lost 2 of my jobs.
First thing to do is you call 911 and then deal with, the rest of the circumstances.
One theme that we see far too often is plaintiffs coming here or to any court, and instead of showing us an estimate of fairy tale land of what was going to fix it, show me a receipt for what you paid to fix the damage.
Yeah, he did fix the damage.
He fixed the damage already, replaced the whole door. You don't have a receipt for that. You don't have a bill. You don't have a nothing, which leads me to believe that it was a lot less expensive than $10,000. So I thought your judgment was generous, given that he had no proof. I would have said goodbye.
Well, he did damage the car. Not that I'm going into history, but as one who has, on occasion, hit a stationary object, even allegedly hit a stationary object, and get a little nick on a bumper on a car. It's expensive to fix a car. So he had a car that looked in perfect condition. It wasn't after it was hit. He's entitled to have it look like what it looked like before.
I just felt there was sort of a bait and switch with a $10,000 estimate, but I already got it replaced.
I think that he said that. I think that he said that
अरे बोला था चूड़ी कंगना राजा जानिया हो, अरे टूटा था रोज रोज पिया बदानिया हो, टूटा था रोज रोज पिया बदानिया, अरे बोला था चूड़ी कंगना राजा जानिया हो, अरे टूटा था रोज रोज पिया बदानिया हो, अब हाथ के मेहंदी हमरो छूटत बाटे, लाले लाले गलिया ओठ लालिया, पिया मोरे सुखत बाटे, राजा मोरे सुखत बाटे, पिया मोरे सुखत बाटे, राजा मोरे सुखत बाटे। रोआता से जिपे ओढ़ना बिछावना हो, अरे धाके कमरिया खेला खिलावना हो, धाके कमरिया खेला खिलावना, अरे रोआता से जिपे ओढ़ना बिछावाना हो अरे धाके कमरिया खेला खेलावाना हो अरे 36-60 के तकिया बितात बाटे लाले लाले गलिया ओठ लालिया पिया मोर सुखत बाटे राजा मोर सुखत बाटे पिया मोर सुखत बाटे राजा मोर सुखत बाटे होता बेकार कायल सोरहो सिंगार हो हर तड़पेला जवानी अनुराग हो तड़पेला जवानी अनुराग हो होता बेकार कायल सोरहो सिंगार हो हर तड़पेला जवानी अनुराग हो और बीपिन तोहरे प्यार से मनवा कुगत बाटे लाले लाले गलिया ओठ लालिया पिया मोर सुखत बाटे राजा मोर सुखत बाटे पिया मोर सुखत बाटे राजा मोर सुख